Kevin, you'd like to introduce A?
Yes. So you kind of have been reading my manager's reports, and Neil's here too, and if he can answer some questions too, I know. But the water rights, the district currently has water rights, and we have permits, 2 permits outstanding, and Paula was going to give more detail on this, but that we're trying to either go to license or renew. We went through an environmental study that kind of got stalled out due to either the water board not going further with it. They had a drought that they were dealing with. They had enforcement issues. So a lot of water rights issues were kind of just set aside. We're trying to get this back going because we have a lot of money that we put into an EIR that's now, we're hoping it's not stale, but we're thinking might need a little more touch up. Paula has been our water rights engineer from the beginning. She has intimate knowledge of the district's water rights and is the voice of the district when it comes to dealing with the state agency. Being that we have 4 new board members, I felt it was important that before we start really getting deep into the weeds of the water rights and you guys having to actually make decisions on them, I thought it would be good for Paula to come up and really give you a Water Rights 101 presentation so that you guys understand the district's water rights, what we're talking about. When you guys are looking to make decisions, you understand what permit, whatever number it is, what that entails, what it holds, and all of that. So with that, I'll introduce Paula Whealan. She's got a presentation for you guys.
Well, thank you, Kevin, and thank you to the board members and President Whealan. Appreciate being able to come here tonight. It's always nice to say I'm going to paradise. Someone asked me if that was figuratively or literally. And I said, I hope both.
Yeah,
but,
really.
You never know till you get here and the tomatoes start to fly, so wasn't sure. But I hope that I can provide some background information to those of you who need it, let you know where we stand with the water rights, which Kevin was kind when he said, well, it got stalled. It moves very slowly at the State Water Resource Control Board, one of the bureaucracies that has a very difficult time in this state making decisions. I think second only to the Coastal Commission. So we've really, and we probably all have our horror stories of what we've dealt with, but it's been a problem, not just for districts like yours, but for individuals and very large cities and small towns and mom and pop operations across the board. So having said that, well, I thought we would give a little background on kind of what are water rights. Kevin mentioned Water Rights 101, and I do like to give that background because I think it's important for us to have an understanding of what California water rights are, just briefly, and then going into what are the district's rights. So if you'll allow me, I'll indulge me a little bit to the sources of water and claims of right in the state of California, which is different than other states. It's probably the only state that has a dual system of water rights, and we're going to talk about that. That makes it flexible, but it also makes it very complicated. The types of water, and there are different types of water, are the first is surface water, and that's water that you can see. Water that's flowing in a channel. It's above ground. You can look at it. You can see it. And to use it in this state, you have to have either a claim of a property right for it, which is a riparian right, or you had to have started diverting it prior to 1914, or you had to get a permit from the state of California. Those are the ways you get to use surface water in this state. The other type of water known as surface water, they call it the same thing, but it is subterranean stream flow. And that's water that's flowing below ground that you can't see. It is hydrologically connected to surface flow. So in some cases where the rivers are flowing down underneath, there's a subterranean component that is flowing in the same direction as the surface flow, but it is flowing in concentrated beds and banks below ground. And people tap into that type of water using wells, infiltration galleries, things like that. And same type of thing for use of that water in the state of California. Same types of way to use it. As I said, property right, a permit, or I don't need that part. A property right or a permit, or some type of a pre-1914 use.
Could you explain property right a little more?
Yes, property right is a claim of riparian right, which I'm going to be getting to in more detail, but I'm glad you asked. And I did mean to say, anytime during the presentation you have questions, the board members should ask. I don't mind stopping at all. Sometimes it's better to stop and do that. So thank you. Property right is a right that exists by virtue of where your land is that you own with respect to where the water course is. And if it is contiguous to the parcel, then you have a chance of having a property right called a riparian right. And you can use the water on your riparian lands. Certain lands are riparian to the source, and that's what's meant by a property right. It isn't regulated by the state of California through the State Water Resource Control Board, but it is it's a property right that's recognized by Superior Court. So, and I'll be getting more to that. Does that give you a little background there?
Yeah, I do
Okay.
want to dig deeper into it. I'll wait for the rest of your presentation.
We're going to dig into it. So, the other type of water is groundwater. Also water that you can't see, but this water is not bounded by beds or banks. It's not hydrologically connected to a surface stream. And it's generally wells that are away from any type of surface or subterranean stream. It can include springs that emanate from the hillsides and run down. Springs, I don't want to say all the time springs are groundwater. If a spring contributes to a water course, it could be considered surface water. But for the most part, groundwater is water that is not connected to any other type of subterranean or surface flow. And right now, it's unregulated by the state of California, by the State Water Resource Control Board. And that's what those abbreviation letters are, SWRCB. The State Water Resources Control Board is the regulatory agency in the state of California that governs the use of surface water. So the dual system of rights that I mentioned, there's two types. There's an appropriative right, which is the system based on appropriation. First in time, first in right. You start using the water first, you have the right to use it first. You file an application first, you have a senior right. It was based in mining law years ago, and people would stake a claim for their mining rights, and that's what an appropriative right system was built on. The other type of right, and this is what Board Member Jacobson was mentioning, is the riparian rights. Property right based on the location of the source to the lands. It's not based on first in time, first in right. It is a correlative right. So if I have a riparian right and right downstream from me, Board Member Jacobson has one, we have to share that water that's in the source. I can't take it all to the detriment of him, and he can't take it all to the detriment of the person below him. A riparian right is not regulated, I should say, by the state of California. If you either have one or you don't. And how it's determined whether you have one is how the land is situated with respect to the water source. So if your parcel is contiguous to the water source, that's fine. But if you split off a piece of your property and you sold it to your daughter, and you didn't reserve the riparian rights to that parcel, if it were no longer attached to the river or the stream, then that parcel has lost its riparian rights forever. They cannot be reattached. Districts don't really deal with riparian rights as much because every time you split a parcel, you guys are serving water to all these various parcels. So you're not really serving water under any claim of riparian right because the riparian right is, they would have had to have reserved the right for all of those parcels. There's very few subdivisions that operate under a claim of riparian right, hardly any cities or districts like this. But for your own lands, or you had property somewhere, you may have a riparian right. And just because you asked the question, I'll go just a step deeper, even though it doesn't really apply to the district. Riparian right water cannot be stored. So you have to take it in real time and use it in real time. It can't be taken in the winter and saved and used in the summer. It has to be taken and used. The rule of thumb is 30 days, but that's not codified. So it has to be taken and used as it occurs in the source. So in some parts of California, there's not much surface water occurring in the summer months, so riparian diversions in smaller creeks and streams, there isn't much that can be done to use it for like irrigation. But there might be enough to use it for domestic use inside a house, or for some other industrial uses. But riparian rights, it can't be foreign in source or time. It can't be segmented from your property, segregated from your property. That can't be foreign in source, and it can't be foreign in time. You can't take it in one period for use in another period.
I have a question.
Sure.
If riparian rights, well, first of all, you said that surface water could actually be underground water if it has, such as an underground river. Now, if surface water rights are riparian rights on landowner's property, and that could be subsurface as well if it's flowing, how do you determine a pool of water that may have a well dipping into it versus a flowing riparian right?
Well, and it's a good
Makes
point. Yeah, and it does make sense. The question is, how do you tell whether you've got subterranean flow or whether you just have percolating groundwater? It's underground. Is it surface water or is it groundwater? And, how do you know that? Because you might be tapping into it under a riparian claim of right. If you are an overlier to that water source, then you either are pumping percolating groundwater or you're pumping a valid riparian right. Your land overlies the source. But when we are trying to figure out whether someone is pulling subterranean stream flow versus percolating groundwater, we have to look to published geologic maps to see what type of deposits are laid in there, where the lands and where the water originates, where the water is originating from. The other thing that we have to do is look at the well driller. If you're pulling it from a well, which most people would be, we look at the well driller report to see what layers the well was drilled into, and then by using the how far down the perforations are, you're able to tell what substrate the well is pulling from. And so it is a opinion by a geologist, an engineering geologist. It is an opinion as to where the source of water is. That opinion stands or not stands unless it's challenged, and then in a court of law, someone would have to decide that.
So riparian rights are less of a right than percolating water rights on land, correct?
Well, I would have some people that would argue with you. Riparian right is the highest form of right that you can have for surface water. Okay.
But if surface water was underground water,
if it's subterranean stream flow, it would be better probably to have groundwater. I would agree with you. Percolating groundwater, it's not regulated by anyone, and
so if it was determined to be riparian water, you could drill down deeper to percolating groundwater and resolve that issue in that manner.
In some geologic circumstances, you could do just that, and some people have done that.
Good, thank you.
It's all clear as mud, really.
I get
It's the stuff. No offense to Emily, but it's the stuff that attorneys.
It pays the bills.
Yeah,
Well, it just
there'll
gives
be
us,
people who have been fighting about
gives us
this for
food
years.
thought about rights. And
It is.
Paula, does this explain all the pumps I see in local creeks and streams that people are pulling?
Yeah,
They're maybe making a claim where they think they have a riparian right.
Well, and they may have a riparian right, and there are a lot of pumps around. Hopefully, all those people have valid claims of right for doing that. You know, it's kind of been the Wild West in some parts of the state for a long time, and as you know, everything's is starting to get buttoned down in a lot of different areas, not just water, but especially water. When we start having a lot of growth and people are trying to stop growth by affecting water policy, and then we also have droughts and floods that add into that, and so things are a lot more focused on who has a right, who doesn't. Are you affecting my right? Are you not? It's as Emily said, attorneys, engineers, everybody who investigates these things is having to spend time and money to do it. But it is a good time, if you didn't know, it's a good time to know what your claim of right is. Because we're not under the radar anymore. And I tell people this all the time, especially with Google Earth. We can zero in and see pumps in creeks and streams. We can see wells. We can see pipelines. It doesn't take much. And that's just, that's a 15-year-old can do that. And so, it's really something, and you guys already have a handle on that, which you're way ahead of a lot of districts that are as big or bigger than yours who clearly don't have a handle on their water policy. And now the time's coming. They're having to put up their numbers and provide their documentation, and they don't have it. So, luckily, you're not in that position. So, let me move on here to the part of the dual system of water rights, and this is something that the district has. A Pre1914 Appropriation, and I mentioned this. The Water Commission Act of 1913 set up a procedure so that it wasn't like the Wild West, so that you had to file a notice, you had to file an application with the State Water Resource Control Board. At that time, it was called something different. But to say, I want to appropriate water from this creek for use on this land in this amount during this season. And that was the appropriative water right process that was set up. So anybody who had been using water prior to 1914 under the old, this is my water notice, could keep doing it and didn't need to go to the state for a water right permit. And what it did say, though, part of what the code said was that to have a valid pre-1914 right, you had to, and there's a variety of things, but one of them is that you had to post a notice or make notice that you were diverting water, where you were diverting it, how much, and for what its purpose was and what the end purpose was. You had to have built the works to do that diversion, and you had to continually use that diversion since that time with not more than a 5 consecutive year break in use. And
years, huh?
Yeah. And it's very difficult for some pre-1914 users to document their water use because during the war, a lot of times the farms didn't get worked, and so there was more than a 5-year lapse. Other times records, are lost in fires. People don't remember. People are dying, as it gets further on. But the pre-1914 appropriation, the district has, and we're going to be talking about it, it doesn't require State Water Resource Control Board approval for certain changes to it. So it's not regulated by the State Water Resource Control Board, but the state requires that you file something called a Statement of Water Diversion and Use with them for a notice that you are diverting that water under that claim of right. It's the same thing for a riparian right. You have to do it, but as it applies to the district, you have a pre-1914 right, and it is required that you file a notice on that, which you did. The appropriation by permit, that's what I was saying after 1914. It's regulated by the state board You can only modify certain things on a water right that's been issued to you, a permit or a license, and you have to go back to the State Water Board for approval. And that's that slow part that I was talking about. So that's the difference between a pre-1914 appropriation and an appropriation by a water right permit after 1914. Percolating groundwater, and I'm only going to talk about it just briefly. You guys do have a well that you use. It's on the far west side of the district boundary, I think. Is that? Yeah. Okay. Okay. You have a percolating groundwater well, and that does figure into some of your water rights. But I'll mention groundwater just because a lot of people are worried what it means. Diversion of groundwater doesn't require any regulatory approval unless you're diverting it, like we said, from a subterranean stream, or if you are in certain counties who have blocked the export of groundwater. Certain counties, I know Yolo County, there's been others that have blocked the export of groundwater. Landowners can pump from under their property. Remember I said if you were an overlier, you can pump from over your property and use it on overlying lands. You also can appropriate it if you're going to take it away from those lands only unless you're in an overdrafted basin. So if you were in a basin that has been fully overdrafted, they will not let you take water out of your well and give it to another basin, 2 miles down the road. Same thing with the counties, as I mentioned. So that's what percolating groundwater, how you can appropriate and use percolating groundwater. And the reason it's been in the news, you may have heard of something called the California Sustainable Groundwater Management Act, SGMA. It's the first real regulation of groundwater in the state of California. Every other state in the union has regulation of groundwater. We have not. And this is just dipping the toe into the water of full regulation. SGMA has identified through California Department of Water Resources has worked to identify 515 basins in the state of California. And those basins are groundwater basins, and they've put a hierarchy on them, whether they're in balance, they're critically overdrafted, where they are in the system. And PID is not within a designated basin at all. You have no compliance issues with SGMA. Yes, sir.
I was at a meeting recently, and I asked that point, and they replied just like you did, and then one fellow rancher sitting over to one side, and he says, well, just wait. It's going to come your way. And I thought, what does he know that I don't know?
Well, I guess, Member Kellogg, that I feel that they've pretty well identified all of them. It's based on geologic mapping. And when you look at the map, and this is what I was going to get to you, those are all the basins. And as you can imagine, that the groundwater basins are pretty much the whole Central Valley, some of the coastal areas, and a few here or there. That's pretty much all it's going to be. The only thing that could change from there is whether you're in a high, medium, or low, or very low. And some of the very lows might change to low, some of the lows are going to change to medium, and some of the mediums are going to change to high. I don't think they're going to find new groundwater basins out there to regulate, but I do think that the ones that are very low, and people were thinking, oh, no one's going to bother with us, but in 10 years, it's going to go up to high. So you tell them that we said that. Don't use my name, though.
So on the pre-1914 appropriative rights, 3,600 gallons a minute, that's a little over 5 million gallons per day that we have absolute rights to.
Where are you?
Well,
Did you
talked
jump ahead?
about pre-1914 appropriate rights for our,
He's
Yes.
back page, yeah.
yeah. And,
Did you jump ahead?
no,
He's back.
I went back to your pre-1914
Oh,
permit rights.
yes. Let's go back there.
And that says we have 8 cubic feet per second, about 3,600 gallons per minute. And it's not storage, it's diversion only. But so that equates to about 5 million gallons per day.
What
Right.
page are you on, Cliff?
His own
Page 20?
calculations.
Oh, I'm on
his own calculations over here. that
I'm
he's
on
got.
I did the numbers myself.
Okay, we're going to
They're not
cover
in
that.
there.
Yeah, they're in there. We're going to
No.
cover.
Well, I mean, I just took 3,600 gallons a minute times 60 minutes times 24, that's 5 million gallons.
You have that as a slide, as our pre-14 right.
So I was curious, before we get too far down the road on that, because this, to me, has been one of the issues Kevin and I have discussed, is our rights for water that flows through our system versus storage. And I know the storage is part of what we're trying to get perfected now, that we don't actually have the rights to. Currently, we only have the rights to this appropriative right, pre-1914, and that's based on this maximum of 5 million gallons a day, is that right?
Well, you have the other rights as well.
Well, that,
You
We're
don't have.
taking it,
You only
but
have
that
one
hasn't
pre-1914 right. Do you, can we cover them?
He's on
You've got it
page
later.
He's on page
20, actually, but we will
Let's try
get there.
we'll get there.
all right.
Let's let her get through.
I'm not shutting you
Didn't want-
down.
Because we were going sideways, and I want to get the
We're
bigger
not going to
overall
go.
picture. and-
Yeah, we're
Page 21.
Yeah, I know where it's at, I'm looking at it
That's, we're
here.
going to come to that.
Yeah, that's a different permit.
Yes, I know, we have two different types of permit.
Yep, I know that too.
Yeah,
Let's get back to
okay.
that. Let's go
Let
back
her,
to that.
let her
Okay.
make her presentation, because you jumped ahead.
well. Let them. You know, and I want to answer all your questions, but I'm trying to build a base and get
Sure.
there. Okay. These are the basins we talked about, and if you look, this is a close up of where you can see Red Bluff, Corning, Orland. You see Chico, and over to the east would be more of where Paradise is, and it's not plotted on there, but you can see that there's not been a basin that has been identified there. So
Because it appears to just be up to the foothills.
Yes.
And then everything above
it
is-
does.
Yeah.
Exactly right. Exactly right. Basins are typically associated with just exactly what you said, President Wilman, is that it's associated with lowlands before it goes up into the hills. I just put this in here because a lot of people want to know about Sigma. They've been thinking about it. They've been hearing about it. And it is going to be a regulation of people's groundwater. It is just in the beginning stages, but 20 years from now, everybody's going to be reporting on their groundwater use. Everybody.
I got a silly question.
Yes.
But it might
That's
relate
all right.
to it. The rivers, the underground rivers up in the mountains, do all of them ultimately go to the valley, or do some of them just dissipate in springs, or how do...
Well, I've always told people that water runs downhill,
I'm a plumber. I know that.
except for in Southern California where it runs towards money.
Good point.
So the
Folks.
California, the Northern California where your streams are and all the systems, some of the water, the components of water, go underground, just like you said. And they are seeking out the lowest place where they can get to. They're going to end up the same place that the surface water does, but what you lose is time. The surface water is going to run downstream quickly, and it'll just keep seeking out the tribs till it gets to the river, and then the river will eventually go down Sacramento and out to the ocean, or in other parts of the state go to the ocean to the north or south of San Francisco, or into the bay. The thing when a stream goes underground, like you're suggesting, the subterranean flow, some of it will just dissipate into the volcanics and the fractures in there, but eventually it seeks out the lower part. And I get that question a lot. And so it's not a silly question, it's a good question. Where is it all going, and why, heck, we ought to be trying to capture some of this. That's what a lot of people want to know. And, unfortunately, to capture it before it gets to somewhere concentrated like the Sacramento River or Yuba or, somewhere, it's very expensive to do that kind of capturing. So you've got to wait till it collects somewhere where you can get, the most for it. But all water will eventually end up in these basins, in these water courses that run through the whole state of California. Does that help?
Yeah, and I think both of us have wells on our property.
Okay.
And my neighbors, there are wells all around me, and their wells are deep, and it's poor water, and they don't have very much. But I am told by the person that drilled our well and that I bought from and so on, that my well is in an underground river because it's just clear and crisp and it's just unlimited, tremendous amount of water. That's what everybody's told me.
You're tapped into a completely different aquifer than they are, maybe.
Right.
Maybe they need to go deeper, or in a different location. And it all, comes down to how deep, where their perforations are,
Your
all of
water
those
rights are
things.
going to be different than mine.
And that's what I was worried about, is that because I sit on something
We're going to
different.
limit how much you can take.
Yeah, Ron Dykstra used to come to my property every couple of years and take samples of my water, and I don't know if they knew that I was different than everybody else around, or what. And I'm always concerned that they one day will knock on my door and
Or
say,
the conductivity meter and push the button, you'll see.
and so, yes, if I was hoping that the direction is not real fast, that they will control our wells. But
Well, I don't think you're in a basin. And so
We're up in-
I don't see that happening anytime
Yay.
soon at all. They've pretty well identified all the basins. What they haven't done is identified the hierarchy of all of them. They've labeled them what they think, high, medium, low. High being basins that are critically overdrafted. And if you go back, to this other slide, you know where they are. You know where those basins are. They're critically overdrafted. They've been overusing the water. And an overdrafted basin means that you are taking out more each year than can be replenished. And so instead of operating like a sustainable basin where you draw the basin down and it rains and it fills back up. Draw down, fills back up. You use it like a bank account, in and out. But what happens in an overdrafted basin, you're drawing it down, but it only goes back up this amount. And then the next year you draw it down some more and it goes back only this amount. So you have a decreasing groundwater table, and it continues to decrease till you either have a gully washer that fills it all back up, or it never does. And that's what you have in these critical basins. And that's what they're trying to do, is to get people to work together to develop a way to make those basins sustainable. Yes.
And just a comment, I'm
Sure.
involved in other things in agriculture, and right now it's a tremendous political thing going on in the valley. Emily's probably very familiar with it, I would think, where they're trying to draw the lines on the basins and who controls what.
Right.
And, whether, all this, plus the personalities that want to be on the different boards that are being formed for it, and different water districts want representation. And so right now it's sort of like you're stirring a pot and it's hot and it's not going to settle down for a while. And nobody seems to know when. And of course we have farmers are notorious for being conservative and concerned with water rights. So the government is doing this to us, and we don't like the government, but we're going to get in there and get our piece of the action. So it's really something to watch.
I really encourage agriculture to get a seat at the table. You're talking about the formation of things called groundwater sustainability agencies, which GSAs, they're being formed in every basin.
We're exempt so far, so we
You
don't
are.
have to worry about that right now.
Well, we kind of are, because that's why we can't have storage, because if we can't use it, it ends up being
No, it has
groundwater.
nothing to do with our storage. That's what we're talking about right now.
Well, it does. The water that flows through our system, if we could store more of it,
Well, it's different. We're talking about these people are on wells, or they have water diverted out of the different ones, the reservoirs and everything above, but they don't, it's not bothering us up here. They don't, so far, they don't want to be any part of what we have. 'Cause
Well, you're not in a basin.
any of their qualifications by the state laws that are involved.
we're not in a basin. I get that.
Yeah.
Our water fills basins if we don't use it. And if they can control how much we get to keep in storage, then that's that much more
Okay,
water
I
that goes
agree.
into
That's our
the.
big problem, so let's
Yes,
get
yes.
along. where she
One of our
talks about
problems is the storage.
1914.
all right,
Let's
back,
go.
Back to the lady
Par-
continuing. Yeah.
Okay, Paradise Irrigation District's water rights. I don't mind being derailed because good information comes out. Butte Creek adjudication. I'm not going to get into the components of the adjudication. If you do need an overview of it, I can send you a copy of it. But suffice it to say that the adjudication of March 1940 assigned rights to everybody who was using water during that time, and there have been various basins that have been adjudicated in the state. Almost every basin in the Southern California has been adjudicated. Butte is another one, and that just means that a court of law has taken all of the rights, who's using them, how much everybody's using, identified all the parties who are using water in a basin, and has sorted out who gets what on a priority basis. And so many years ago, it's 77 years ago, they decided that Paradise Irrigation District has a pre-1914 claim to 8 cubic feet per second of water. This is what you were talking about, the about 3,600 gallons a minute, and it's not to exceed, where you can divert it, it's 8 cubic feet per second, excuse me. But by the time it gets to where the place of use is, they accounted for conveyance losses and said it would be 4.5 CFS at the place of use. That is the first water that has to be used by the district, or counted as used by the district, because it is your oldest water right. It's a direct diversion right. And remember, I was saying some rights are storage, where you can divert it in the winter months, store it in a reservoir, and use it in the summer. This is not one of those. This is a direct diversion right that the water has to be used on a real-time basis. It can be used for 11,250 acres within the PID boundaries, and it can be expanded beyond that use. When we expand the other places of use, this will be able to be expanded as well. But this doesn't have a water right permit. You'll see that it says it's a statement of water diversion and use. And that is when you have a claim of right, like a riparian right or a pre-1914 right, you have to file one of these. It's not regulated by the state of California only to the extent that they want you to file a report on water use every year. And that is enforced by the State Water Resource Control Board. So before every June 30th, we have to file a statement of water diversion and use supplement for this diversion to say how much the district uses on a monthly basis under this claim of right. So we have different colors of water rights. This is a different color than your other rights that you have. The pre-1914 right has, I have no feeling that it's been challenged. There's no reason to believe that it's not in good standing. I don't know if, I don't mean to turn on Neil, but if you have any other feelings about whether or not we have any trouble using that much water each year?
No, I don't.
No.
I don't think so. I think we're.
Right. We may falter a little bit in the winter, but it's a good claim of right. It's been recognized by a court of law. I won't say it's unchallengeable, because I think anything can be challenged, but there's no indication of that. So this is your oldest and most valuable water right.
Can you speak to, again, I just need a little clarification.
Okay.
8 cubic feet per second, but rate not to exceed 4.5 cubic feet per second at place of use.
At the place of use.
What does that exactly mean?
Okay. Where the adjudication had you diverting from was further upstream. And it said that you could take it under control here, and at the time it was being taken down and conveyed down to irrigation. This was more of an irrigation right years ago, and it was where it started into the place of use that was being served. That was what they called when it reached the place of use, and they expected that you would have to take 8 second feet in order to get 4.5 second feet down here, based on the conveyance losses. So that's what that means.
That makes no sense.
Okay.
We had open ditches.
You had open ditches. You had a lot of losses.
Yeah. Mm-hmm.
There were a lot of losses. So they said, instead of just telling you that you could divert it at 4.5 up there, they recognized that In order to get 4.5 feet down at your place of use, you were going to have to take it at a higher rate
Okay.
in order.
But the recognized pre-1914 appropriative right is for no greater than 4.5.
At the place of use.
Well, that's the only reason we would take it is to use it.
Well,
So it's really not eight cubic feet per second, it's 4.5 that we can use. That's what's net
Yeah.
available to us, right?
There's still carriage loss.
There's
Still what?
there is still carriage loss.
Still carriage loss. It's much smaller now.
Right.
We still claim certain water under this right as carriage loss.
But even if you had no carriage loss, you still can't take more than 4.5.
Well, I don't like to say that we don't have an 8-second foot right.
That's the way I read this.
No, the adjudication says you have an 8-second foot right, and that's
But
what
don't
you
use
want
more
to
than
claim.
4.5.
So wouldn't we have an argument that we've reduced the losses in our system today to get more of that allocation, that 8 CFS?
Or is it merely to our benefit because we have greater control and less loss?
Well, you have less loss because you have greater control, and so that is to your benefit. You know, 4.5 feet is what they expect that you will be using at the place of use. But if they limited everything, someone went back to court and said the only thing they can take is 4.5 up there, you would get less than 4.5 at your place of use. Because as Neil said, you still are going to have some carriage losses.
Paula, could our place of use be outside the district if we?
No.
No, it could not.
No, it's designated where it has to be in the adjudication.
Okay.
Yeah, it identifies that area.
And there's no
So-
consideration for the number of points of use, huh? No. apparently
Well,
not.
no, I mean, where you're taking under control in
Right.
Butte Creek is your point of diversion.
And that's it, yeah.
It's a great right.
Good.
I like those types of rights. I like to be able to say that. A lot of people don't have good rights. PID's most senior right, as I mentioned, and they've got to report it under their pre-14, so you can't just say, oh, we're going to report it under our permit instead. We have to report it under this right.
Yay.
The Paradise Irrigation District's second best right is the permit that it got back in 1916. Just missed the 1914 date. But in 1916, a water right application was filed and a permit was issued. And the permit had these parameters: 6,700 acre feet to build and put Paradise Reservoir in, 2,800 acre feet to build Magalia, take water year-round from the creek, use it for municipal, irrigation, industrial, and recreation, and use it anywhere within PID. And that permit, we've been using it. You used it to build Paradise. You used it to build Magalia. You have been using the water that way, where you diverted it all year long and used it under your claim of right. But we realized something back in 2006, or I'm trying to think the date that we filed those petitions, 2007, that when we started looking at the spreadsheets that Neil was putting together and how water was actually being used up here, is that you guys were also not just diverting to storage, you were taking water by direct diversion. Meaning, when water was flowing into Paradise, you were taking it at the same time. The same time it was flowing in. It wasn't just coming in the winter and you using it in the summer. That's what you used to do as an irrigation district. You didn't have a big demand during the winter months. So you just let it fill up, and then everybody turned on their sprinklers and irrigated their crops in the summer. Well, when that stopped happening, you started needing more water in the winter. Or when I should say, when the irrigation lessened and the municipal increased, you started needing more water in the winter months. And so all of a sudden, you guys were operating by direct diversion instead of just diversion to storage in these reservoirs. And that's not allowed under your water rights. And just so you know, you're not the only party that this has happened
I
to.
was just going to ask that. Surely this is happening
City
all
of
over
Santa
the
Cruz.
state. Yeah.
City of Santa Cruz. Fallbrook Public Utility District. Just I'm spacing right now, but many, those happen to be two that I'm representing, but many have found to do this. And so what they had to do, and what we did on behalf of Paradise Irrigation District, got together with your general manager and Neil and everyone. We quantified what we'd been doing, and we filed a petition, and I'm going to talk about this in a minute, to correct that. But I jumped ahead of myself. Let me go through the next permit, and then we'll come right back to the petitions. But this is what this water right permit allows. And when you see it says beneficial use date December 31, 2007, that means that you told the state that by that date you would have put all of your water to beneficial use, and you would be ready to have a license issued on it. Because right now you just have a permit. The license is the cap of the right. It perfects the right. And when the right is perfected, they issue a license. And so this expired in 2007, and we're addressing that in some petitions. And I'll get to that. I'm sorry, I wanted to go through the rights first. It's hard. It's hard not to be jumping back and forth, but I'll do my best. I'm sorry if I've made some confusion.
Can you
Yes.
explain the difference between storage and direct diversion based on
Yes.
how long what storage requires?
Right. A storage right, which is this permit, allows for you to take water and place it into storage and hold it for a period to use later. It isn't just 30 days. That's been for purposes of licensing, it is. If you keep it in there longer than 30 days, they figure you stored it and you're going to use it later. And that's called diversion to storage.
It's called, well, duh.
And that's what your permit allows. Direct diversion is when the source is flowing and you are putting it into storage and using it at the same time in the winter months to run through your house, to run through this business, to run through this industrial use. All of that's happening at the same time that it's raining and water is flowing into Paradise. And that's called direct diversion. Your water right permit did not allow that. And so we're trying to correct that.
Question.
Yes.
Our 1914 water rights allow, according to my new calculations,
Right.
3 million gallons a day. So how do you balance that then? Is that coming into the same?
It is coming in the same system. We're reporting that amount first, but we need more direct diversion than just what that allows for. That's why we've got to try to convert this right to allow direct diversion.
Exactly, but once you perfect this, we will still have that 3 million in addition to this, right?
Well, you have that first. That's your first use, and then you'll have this in addition to that.
In addition, okay.
Yeah. So the water right permit, the second one that you have, was filed in 1965. It has the same beneficial use date, and it allowed for the storage of an additional 8,800 acre feet in Paradise Reservoir. And the diversion season was not year-round on this one. It was October through May, and it allowed the same municipal industrial recreation. The right provides for the additional storage in Paradise. We had to have made use of it in 2007, which we didn't. But the big difference between this permit and the one that we just looked at is that this permit is limited by something called Term 91 that was developed in the 1970s that said anytime the delta is out of balance and the state and Fed projects are required to release water to meet downstream in-basin uses, that your water right permit would be curtailed. Okay, and it's not just you, it's everybody who came along after that time that is tributary to the delta. Well, this Term 91 makes it very difficult for people to divert water in the summer months under their water rights, but luckily, this is more of a diversion to storage in the winter, and really where you would be clipped off with Term 91 would probably be the month of May. The reason that it's never happened is that you have never diverted, you, the district, has never diverted water under permit 16040. All diversions are being made under your other permit and your pre-1914 use. And that's just because your water use hasn't been as great to require the use of this permit.
So if we don't use this permit and the twin tunnels go in, they can't make us give them more water for the delta.
Boy, you are just like venturing off into a whole new realm there. I'm not going to touch the twin tunnels.
Well, the single tunnel.
Good, we hope they never do
We're
get
just
cut.
not even going to get there. You know, there's so much to cover on that we don't have time. But suffice to say that this permit needs to be extended because you haven't made any use of water on it, and the beneficial use date expired in 2007. So we filed an extension, and that's what I'm going to get to next.
On this one.
Yes.
Is there any benefit in our application to having recreation be part of it? Because I know that some lakes, Almanor, et cetera, they're able to keep their lake high for recreation purposes in the summer before they start draining. Is it any benefit that we are doing that? Is that accidental or intentional? Or?
Well, you applied for recreation because you use it for that.
Right, we do.
But it isn't what drives the... I don't want to speak out of turn, but Neil, recreation doesn't drive the capacity of the reservoirs.
It doesn't
No.
allow
The-
greater retention of the water or anything.
You are allowed to only
Or
store what
detention.
you're allowed to store,
That's it. Yeah.
and that is it. And that includes the use for recreation. But recreation is an incidental use, basically, to your reservoirs. These are water supply reservoirs.
Well, maybe when we get our new dock in and the states dump so much money into it, they'll allow the-
And really the big question, what we wanted to talk about, and I think this is why, Kevin, is that you're going to be embarking here in the next few months as a board, looking at some things having to do with petitions. Now, we filed petitions on permit 271. That's the first one. That was the one that was filed in 1916, and it allowed for the 6,700 acre feet in Paradise, 2,800 acre feet in Magalia, which has been, as you all know, Division of Safety of Dams has kept that at 800 acre feet based on safety concerns. The maximum annual beneficial use that we have estimated through Neil's work and the State Water Resources Control Board's review of Neil's work and concurrence with Neil's work is that the maximum annual beneficial use that we can claim is about 7291 acre feet. That includes that 725 acre feet of conservation. What this means is that we filed a petition on this permit and we said, we're done. We've perfected this right. Give us a license for 7291 acre feet. And that was part because we had perfected it, and part because the State Water Board was pushing Paradise to do something. They said this was issued in 1916. It's one of our oldest permits still out there. And you either take a license on what you've done or you start forfeiting some of the water.
Was this beneficial use calculation done during when we were conserving because of the drought years?
Not during this last drought year. We took it on a 10-year, let me get my glasses.
average use.
We took it on a 10-year, floating 10-year use that ranged from 1998 through 2007. And I think that's the one that we used, 1998 to 2007 with a floating water year. Yeah.
So you based the usage on what it was back then before the permit expired in 2007?
Yeah.
Okay.
We took the best we could get before it
Yeah,
expired.
Makes sense. Okay.
And there was a lot of work on the part of Neil, because he had to keep, his spreadsheets are a work of art, and keeping track of the water and how it was used to put us in the best, and I say us, I'm considering myself part of the people here, put us in the best light in order to demonstrate the biggest amount of beneficial use we could get. And that's where we got that 7291. And so the petition is pending with the State Water Resource Control Board. And also, in addition to saying, hey, we're done, we've capped the use, we asked them to give us direct diversion as a method of diversion. Remember when I mentioned that we don't have direct diversion? We asked them, we said, you know, we're not asking for more water because we can't. We just need a different method to take it, not just under storage, but also under direct diversion. And those other groups that I mentioned, they're also doing the same thing. City of Santa Cruz did it first, or about the same time. Fallbrook may have done it first. Then the other thing that we're doing is adding a raw water bypass facility that you all put in. We had to name that as a point of diversion. It's another place where water is taken under control. And then finally, the last thing was the addition of hydropower as a and I have a typo there, and I severely am sorry for that. It was supposed to be hydropower as a purpose of use. And we've added that under the petition. And then finally, the last thing is we've added different lands to be added to your place of use. Instead of 11,100, which is what this permit was for, Del Oro's Lime Saddle, Paradise Pines, and Magalia districts are added to get up to the 35,000 acres. Now, I've given you guys a map that's bigger than the one that's in the PowerPoint presentation. And on there, you can see the various districts. And if you need a bigger one, Neil has that, I'm sure, in his office, bigger, right? Yeah, we can make bigger ones. But that is the map that accompanied the petitions. And so you can see all the points of diversion on there, where the reservoirs are, the place of use, which is known as 35,000 acres under this petition, and you can see where the Lime Saddle, Paradise Pines, and Magalia districts are. So that is pending with the State Board, in addition to a petition we filed on the second permit. This is the permit that you requested in 1965. Because we've used no water under it, we have to get an extension of time. So we've petitioned to add an extension of time to this to get an additional 25 years from the time they finally issue it. And what we told them that we would do during that time is to increase the storage at Paradise and to restore storage at Magalia. That's the goal. We also seek to the amount taken from the source not to exceed 8,800 acre feet per year. That's what the permit was issued for. And then both permits together would not exceed 18,300 acre feet per year. The same as the other permit, we have petitioned to add direct diversion, the raw water bypass facility, and the hydropower plant. And again, the 35,000 acres, so we could use the water anywhere within that 35,000 acres. Both of those petitions have been pending since 2007, when we filed them.
Brother.
Not unusual. State Board has about 645 petitions pending, and I think they granted 9 of them last year.
Where are we on the stack on somebody's desk?
Well, we've been told, we've gone over there a couple of times, and Kevin's been part of that, and your former general manager, Neil. We've been told that they want to clear this up. We offered to do the work for them. Neil did the calculations for them. Because one, they don't have time, they don't have the staff to do it. And they agreed that we would do that. They also agreed that we would write the terms. And we've done all of that. And we're waiting for them to provide us with a draft license for permit 271.
When did they come to all these agreements? 3 months ago?
Well,
2 years
wouldn't
ago,
be,
6 years ago?
I hesitate I shouldn't have used the word agree. They nodded that that's, something they could do. They're not going to put it in writing. But it's been probably, it was, no, when we went up there the last time.
Was it April or May?
April or May of 2017.
Oh, so just recently, yeah, all right.
Well, recent
Well,
in
when I
water
say
board
recent,
time.
this wasn't- all of these maybe agreements were
Yeah,
back
yeah.
in 2007. They were.
You're right with me on water board time, because that is, they run on a completely different time clock. Yeah, recent.
in perpetuity, or there's a term?
25 years.
I've asked for 25, we've asked for 25 years,
Okay.
which
To meet these
is a
conditions, yeah, right.
25 years from the time they issue it. Yeah.
Yeah, not
So if they
from
don't
the
issue it for another 5 years, 25 from there.
And that's the license duration? Is that what?
No,
No, no.
no, excuse me. That is the extension of time in order to enlarge Paradise
Oh, yeah,
and
okay,
raise
sure.
Magalia back up.
Okay.
The good point though. The license once issued, it's good in perpetuity.
Okay.
You don't need to do anything else. It caps it. It gives you that water right, and it is always your right as long as you abide by the terms and the conditions of the license,
Will
and
that
as
be
long
in-
as you put the
will
water
that
to
be in
beneficial
writing?
use.
Will that be in writing?
That is in every permit that is turned into a license.
Good.
I've read that there's been talk that the state may tinker with the pre-1914 water rights.
Yeah, they've been threatening
they
it.
can- You're right, Dan.
Yeah.
I mean, things
Yeah.
can happen.
Well, and when they're talking about tinkering, I think what you're referring to is during the drought, they were trying to subordinate pre-1914 rights. And that's what I think you meant by tinkering. They're not looking to take them away. They were looking to say, yeah, you've got a senior right, but, you haven't been
more-
using it.
You've got more than you need,
Yeah.
so we want to
And
share
so
it. Yeah.
there's been that discussion. But one of the big things I wanted to talk about tonight, because this is coming up for you guys, is environmental review for pending petitions. The petitions that we filed, yes, they've been pending with the State Water Board. And as Kevin mentioned, years ago, back in 2008, 2009, you guys started an environmental process, and you hired a firm to do the environmental document. They got as far as issuing the notice, and there it is, 2010. You guys circulated a notice of preparation, and you said that you were going to be processing these petitions. As a public agency, Paradise Irrigation District is responsible for doing its own environmental document. So you circulated that, and then during the public comment period of that circulation, you received comments from these parties. And what I mean by comments is most of the comments were directed at, we need more information, we think there could be impacts to fish and wildlife. That was from California Department of Fish and Wildlife. We want to understand that we have no impacts to cultural resources, and we want to make sure that our prior rights are taken care of. So, a variety of different things in the public comment period. After consultation with the state board staff, PID decided then to make some amendments to their original 2007 petitions. And instead of doing what was said in this 2010 circulation, we decided to go ahead and go to license on that first one. When we first circulated this in 2010, we thought we could get an extension of time on both of them. And the state said, no way, you better take a license on that earlier one. And so that was what we made the change on, and that's why it's not the reason why the environmental got delayed. It got delayed because of this, but also because the political climate was starting to change, and the State Water Board wasn't processing these things. We didn't want to go forward with it and then have it turn stale, and then also the drought hit after that, and then nobody was working on anything. When I say nobody, I'm talking about the State Water Board. So we prepared this detailed documentation of beneficial use. That's what I was talking about, that Neil prepared for you all. And we got concurrence preliminarily from the State Water Board. And the group called De Novo Planning Group is your environmental consultant that you guys retained. And they are revising the project description to meet what I described tonight. They're also going to be meeting with these environmental groups to see whether additional studies are needed, because the other ones might be stale, or whether we can just touch them up, or whether no new studies are needed. And so that's where they are right now. De Novo Group is doing that. The next step for you all is PID is supposed to recirculate a notice of preparation of the new EIR. They said it's proposed for the final quarter of 2018. The State Water Board staff was nodding their head, and hopefully, they'll go along with us. State Board is supposed to issue a public notice of the petitions. That's something different than a public notice of the environmental document. This is a public notice of the petitions, and they said that they could get that out the mid to end of 2018. And it's basically a notice that they give to all the public, regulatory agencies, parties like Fish and Game, U.S. Fish and Wildlife, National Marine Fishery Service. They give notice that you are seeking changes under your rights. And those people have a chance to comment or file protests against the petitions. We're hoping that PID can adopt the EIR in 2019 and that the State Water Board could issue the permits in 2019. And basically that schedule is, it's ambitious, and it's if we don't get caught up in another drought and lose staff, and this would be light speed. This would be moving at light speed.
And we're assuming that none of these other agencies that objected before, or groups, are going to object again to this and want an
They will.
impact?
They will.
And isn't that going to slow the process up?
Yes and no. They will. None of those parties had anything that was insurmountable. They have to comment so that they will have standing at the State Water Board during the hearing process. And so sometimes even if they don't have anything to really complain about or have issues with, they will file a protest to have standing. Emily, I guess, you would probably agree with that. I mean, you have to have...
Preservation of their rights.
It's a preservation of their right to have standing. And so those people will you'll probably get more protests, more comments. That is not unusual at all, and that's what the process is. This is the project that we're doing. This is how we're going to mitigate for impacts. This is where we can't mitigate for impacts. Tell us what your problem is. Maybe we can change our mitigation to fit it, and if not, you as a board would have to adopt a statement of overriding consideration.
Can any of the water districts or agencies that want to have our water south come up with anything here, or is it just the sphere of influence
Should be just here.
to where our water's coming from?
It has to be someone who has standing, either by saying that you have impacts to the environment or saying that you are impacting their prior rights.
So somebody can't say, you're going to supply less water to the delta, therefore we have an objection with it?
Well, they can't get your water. It's your water right.
Well, they get it eventually, getting it now, is my point.
No.
And can they object
can't-
to us perfecting a permit? Let me,
I'm just asking to be able to talk.
No, go ahead.
But interrupting what
can
you're
they, I lost my train of thought now. Can they affect this permit application by objecting to that because we would be doing harm to properties that are not in our sphere of influence here, but that are directly affected by how much water we don't get to keep and use here that goes south?
No, they have to have a direct connection to what you are seeking to do.
That was my question. So the people in Sacramento cannot object to an environmental issue?
What people?
Oh, people like farm agencies that control 58% of our water in the Mid-Valley, and
I'm not
people who
following
want
what
the
you're...
water for the Delta, the people that are not in our sphere of influence here. That was my question.
Well, this water flows downstream,
Yes, it does.
and it flows down through the Sacramento River and goes downstream to other parties. Someone would have to have a prior claim of right to challenge an impact to them. We didn't really get any of those in the first time around. I'm not sure that we're going to get any prior right impacts. We're going to probably have environmental concerns, fishery. It would be your number one thing.
This list is going to,
Not fishery in the Delta, fishery in your
Yeah.
stream. And so I guess I would say that it probably would not be entertained by your council to have someone protest who didn't have standing. When I say by your council, would recommend to you that we respond to them that they don't have standing. So, but you are going to get protests, and they'll probably be associated with impacts to fisheries up here. You're taking water out of the stream, and, they just know it's bad. So, no matter what it is. Yeah, I'm sorry.
A lot of what Cliff is worried about, in a practical matter, can't happen because we have the water rights. That's what we're talking about here, securing them. Below us, the water rights cover everything as you go down. Different districts have rights to
Absolutely.
and diversions that go back to pre-1914.
They
and
do.
everything else. And Butte Creek itself has environmental groups that are very active in protecting Butte Creek back to its origin.
Well, yeah, they filed protest here.
Hence riparian rights and downstream flows being
Butte-
diminished by water usage upstream.
Well, our watershed is Little Butte Creek that flows into Butte Creek. And then if you're going to diversions that are water sold south, most of the ag irrigation districts in the valley sell water in a dry year in Southern California, and they idle land, and the landowner, I don't know how they share it out, but it depends on the market. It flows up and down
Right.
what the water's worth. And they make sure that they don't use the same fields more than, I think it's 1 or 2 years.
They rotate.
They rotate the fields. I'm not sure how frequently.
Yeah, but they protect their water rights that way, so those districts still own the water. The big fish down south can't come in unless they have a pocketbook to buy the water rights from that district. They don't have anything to it. So they're able to sell it as a cash crop, depending on the year and the demand and all that. So this year it looks like demand's going to be great. So it's all protected by these long-term water rights. And Dustin used to mention the water rights that go back all the way, that they were trying to break some of the water rights up here that we have protecting this system. But it all comes down to, come on. The saying is, people drink whiskey, but they fight over water in California.
Whiskey's for drinking, water's for fighting.
Yeah, drinking water.
Well, there are a lot of very complicated agreements, priority systems, and the water that is excess in the system to you goes to somebody else downstream of you. You have a right in the system and a priority that is protected by your priority. No one can file a protest and take that away from you based on something that they want. You're protected by the priority system with regard to your appropriative rights, and the pre-1914 right is a court adjudication. So those are how you're best protected. And if somebody alleges something in the petition process of the public notice of the EIR or the petitions, you will be stating correctly through your counsel when they're responding that it is not germane to the issues raised in the petitions. And the only thing that people can file a protest against is the action that is proposed by the petitions. They cannot file a protest on the underlying claim of right. Mm-hmm. And that's a big thing, and districts are using that all the time. Am I going way too long?
No, you're fine.
Oh,
But
I'm sorry.
I think just to kind of circle this all back around, because we're talking about protests of the EIR. Mm-hmm. I think, and correct me if I'm wrong, our biggest exposure to the change that could come about through this EIR process would be the increase of the requirement of a release. So right now,
bypass.
we release a half CFS that we're required to. If that release requirement goes up, I think that's what we've talked about from our standpoint, is that's our biggest exposure, and that's the environmental impacts
Right.
that we would be affecting.
We're going to be looking at De Novo will be looking at your exposure on that, because right now, Kevin's right, you have a bypass that means at all times you're diverting, so much has to go by the facilities and go on downstream. If Fish and Wildlife, Fish and Game decides that that's not enough and you negotiate something higher, that means that it takes longer to fill your system by releasing that water. And that would probably be one big thing that would happen, but that isn't that doesn't come about because of the people down in the Delta or Sacramento.
That's based on the environment.
That's a regulatory
And
agency.
we're on a tributary that's very highly regulated and is very, precious to the state of California.
Maybe we can give them a little bit of that 4.5 or that difference between 8 and 4.5.
The loss, the carriage loss.
You're saying they can have the invisible water. So.
A nuclear,
Well, I just
renewable.
I wanted to
Add water.
finish up in the next steps. Just that's kind of where we're going. We're waiting to hear from the State Water Resource Control Board staff on a draft license, and Ben Ritchie, who is your de novo planning environmental consultant, is working on the project description, but with reason wants to have that in hand before he finalizes it to make sure that we've got what we think we have.
Just an update too on that is that we do have a contract with him, and I believe the contract amount is about $350,000. He's used approximately $270,000, so there's an additional amount on that contract still outstanding. There's going to be a change that's going to need to take place within that contract because there's going to be more work. But the direction we gave him is to continue working under that contract to discover what the additional changes are going to be so that when he comes back, he has the additional changes in hand for the board. So he's working under his current contract that was established when he did the first studies, and then he will then come back for the change.
I've got a copy of that environmental impact report. It's available to any of the directors. All you have to do is ask Kevin for it. And you'll soon find that the front part of it needs to be changed because it's a description of the district that's changed somewhat. And some of the rest of it will be knowable. But you will find out about frogs and all the different
I have a copy of it as
animals
well.
that are in the creek. So.
And the project description itself is is going to need to be changed because the petitions are different than what was filed back then.
Yeah.
So yeah, you're right. And they're going to use that as much as they can. They don't want to reinvent the wheel, but the agencies dictate whether or not something is stale. So that's kind of wraps up what I had to say. I just put this at the end for you to read at your leisure, just who we are, just so you say, well, who is she and what does she know? And you might still say that after you read this, but I appreciate having the opportunity to work with the district. It's been a long haul. It's sad that this is the way the bureaucracy runs, but also it's kind of been good in some ways that it took a little longer because we found out some things that we might not have known back in 2007 that are going to benefit the district that we've made corrections for. So there's plus and minuses. Are there any other questions?
I've got one.
Yes.
Maybe because you're in this industry, maybe you know a little bit more about it. And I may be, not thinking this out right, but the state or the voters passed that initiative that increased taxes to support the building of places like Sites Reservoir, okay, for additional storage. And now the state is saying that none of those pass muster, and they've come up with some trumped up reasons as to why they can't get any of the funding. Do you think, in your opinion, that it has anything to do with the lack of funding for the twin tunnels and the effort to maybe take some of that money for what might be called a beneficial use, because they're not going to use it to fund places like Sites Reservoir, and then that becomes the funding for at least one of those tunnels?
Do you think
Is
she's?
there anything at all about that? Or?
Are you taping this?
I was going to say, do you think
Yeah.
she might really know the? I don't think anybody knows that.
Well, even if I did, I wouldn't say it in a public meeting. And I think that those reservoirs aren't probably the best locations for water, but they're kind of all we had. And I think some of the better locations for water aren't being looked at because politically they're probably
Impossible to ever achieve, yeah.
to achieve. But they said, I know the same thing you know. I read the articles too about why Sites Reservoir didn't qualify for the Prop 1 money and what different pieces it didn't have that would allow it to use the Fed money. They've reduced the twin tunnels quite a bit.
No, I know that, but they've also denied funding for any of the applications.
Well, the Temperance Flat Reservoir was another one, and the enlargement of San Luis, which was a one that was being considered. I think we need to build reservoirs here, and I think we're going to be hitting ourselves over the head with a hammer that we didn't do it sooner.
It's the politicians that need to
But-
get over the head with
Oh,
it.
I agree.
Yeah.
I'm just wondering if that's where the funding
Real
is.
people.
I don't know.
earmarked for
I can't say if
needs to be
that's
turned
where it
away.
went or not. I do know the same thing you did, that they've all of a sudden they've thrown a lot of
Roadblocks.
roadblocks up against those 3 reservoir sites, and it's a shame. But we're looking at Temperance Flat for some. We're looking at Temperance Flat for some potential. They're not potential, but a group of people who are looking to build it independent, and it's a great reservoir. It doesn't really help the Delta. It helps the Central Valley, some of the Delta, but yeah, it's tell you, as long as we're alive, they're going to be fighting about water. There is no easy answer, and there's a lot of people who don't want to resolve it. Yeah. Yes.
Doug and I went to a meeting a couple of years ago when this first started in Chico, and they're trying to explain the money from the proposition, and the local Republican politicians who support Sites Reservoir, and most of the people there supported it. The only thing we found out is that the way it was written up is there's environmental things in it that actually control most of the money. And that's been from the very beginning. And when they got through explaining it, everybody was going, well, what's going to happen? And their answer was, well, 4 or 5 years from now, guys, if we play our cards right, we might have a chance. So politics is going on now. And the chance we were working against is environmental groups that have their own axe to grind.
Well, environmental lobby in this state is very powerful.
It's huge.
Very powerful.
One last brief question.
Yes.
LAFCO, they're probably not a concern at all, are they, in regards to change?
I think LAFCO, you will have to deal with them on the expansion of your sphere of
Sphere,
influence.
right.
And, obviously, they have their own job to do to determine whether or not the sphere should be expanded. But hopefully we'll have done all of our homework before that application is made, because it tends to go with the water rights and what the land use is, how the land use had been provided for, in the initial LAFCO plans. So I don't see it as being a roadblock, but it is something you're going to have to go through. Yeah, for that. Anything else, Kevin? No? Okay. Great. I'm sorry to take so much of your time up.
Oh, thank you, Paula.
It's not an easy subject. It's either a 5-minute or a 2-hour.
Thank you very much.
Well, you're under 2 hours, so thank you, Paula.
Yeah. And Kevin indicated that it would be all right unless you guys need me further to leave. So I don't mean to be rude, but if you do have any questions for me, Kevin can tell you you can email me directly. You can call at any time.
Ward had to leave.
Yeah, he had to leave.
Anybody in the audience have a question briefly before? Let's try that briefly. Go ahead, Robin. You got it.
Oh, do I stand up or does she stand up?
If it's real short, go ahead and stay there. If it's long, then go up. Yeah.
Well, stand up then. Here.
Then come on up to.
Over here. I wasn't sure who was supposed to be. After I detailed the comments there. Let me get the paper out.
Hi, I'm Robin Huffman, and it's been a long time since I've looked at the initial study. I do remember it from way back, and a lot of things have happened since then. I suppose the biggest thing is the potential sale and interest that PID may have in the DeSabla PG&E Centerville project area. And I don't know if that is going to complicate this petition.
It shouldn't affect it in our application right now, I don't think, should it?
It's not connected
No.
at all
No.
to that.
The only connection I see are the maps. It looks like there's overlapping areas.
And there might be some overlapping place of use. But as far as the base rights that we're petitioning under, they're not affected by other rights held. Are you talking about PG&E? Mm-hmm. Yeah.
Yeah.
It's not affected by that, and it's not going to be based on that. The state is not going to hold up action on PID's rights in waiting for something to happen on the PG&E ones. They both may cover the same place of use, and if something is going to be done to purchase or somehow get those rights, that'll have to be disclosed. And it's pretty transparent. It's all public information.
Does that answer your question, Robin?
Well, they're overlapping watersheds, and so
Right.
seems like there might be conflicting. I mean, say someone from Washington State buys it, they're going to definitely be worried about whose rights to the water in the watershed.
Well, people from Washington State wouldn't be able to use that water. The water is only able to be appropriated where PG&E has it now, and it can only be used for the purposes that PG&E has under its water rights now, and it can only be taken from the source that PG&E has its rights to now. So someone in Washington might well buy it, but they can't change those things without going through the water right process like we are, which is a public process. But they can't move the water from here up to there.
Maybe they want to use it for hydropower, something like that.
See, but again, that shouldn't affect us.
If they want to use it for hydropower, they could well do that. It's a non-consumptive use, and it's just where, as you know, you have a hydropower plant here where it runs through the turbines and it returns itself to the creek. Again, that would probably, it may require them to make some changes to their right, or whoever ends up with the PG&E right.
Del Oro wrote a letter last time, and so I looked at that again, and it seems really controversial. I mean, the new lines are all their territory, and I don't understand why go there. Why ask for permits in Del Oro's area? So I can't remember why. If you could briefly state, because you go to all the trouble for an EIR, cost who knows $1 million, and then you've got this controversy. So why expand the map so much in the northerly direction, in the Lime Saddle direction?
I can answer that. Currently we actually deliver water to Del Oro, and we have no right to put the water up there, so we have to do water exchange through our
Right.
well right now. With having the place of use changed to where it's deliverable through Del Oro, we have the opportunity for them to take water from us in lean years, and with them have failing wells and any type of water issue, that we would have the availability to sell or to transfer water to them.
So it would benefit them.
It's mutually beneficial.
Did you understand what he just said? We do
Yeah,
have a swapping agreement with them.
And that agreement
sentence.
has occurred since that letter was written in 2007?
We've had a wheeling agreement with them, but since 2011, we've delivered emergency water to them in 13, I believe. And in that, we delivered 100 acre feet, I believe, and we had to pump 100 acre feet out of our well just because of that, even though we didn't really need to pump 100 acre feet out of our well.
If they complain too much, we'll just cut them off.
But you're expanding the lines.
That's a valid
problem.
question.
Yeah.
Yeah.
And may I just add that the place of use is being expanded to accommodate those types of emergency equipment down, and it's not unusual for districts and cities and other public agencies that are connected like this to have overlapping places of uses to accommodate that and to allow for more flexibility in wheeling the water around. Most most of the districts in and around the city of Ukiah have that type of a system where they each name each other in their places of use so that they can operate under those agreements. And I think the Delaware letter that I think you're referring to, when they commented on the EIR, or the Notice of Prep, is that what you're, again, for standing, but not objecting to the underlying ability to serve each other with water.
Okay.
I didn't see it that way, but I don't blame them for writing a letter so that they would have standing, because they are involved in having their lands named as the place of use.
And then, if I understand it right, the rest of the land, which is all the way to the valley, toward Butte College, all the way down, and just a huge area of land in the fingers of the canyon, which isn't even useful, most of it, for cattle grazing. It's so steep. So by having this more land, we can claim a larger water right. Is that what I heard?
Mm-mm.
So why expand into such?
Why expand in such unusable land?
Yeah.
And I'm not sure why it was drawn that way.
Originally, it was drawn. It was originally drawn for wells in the valley. That the thought was that we might have to that might be a drought supply. Those with Sigma and all the other stuff, I think, have kind of dried up, and especially with our current water production, that's kind of a dried up issue. But it's just a sphere. It's just it's a land. It's a dot on a map, and it doesn't mean that that's where our water is going to be flowing to. It's still a LAFCO issue even after that, to annex those lands into the district. But right now, we were just trying to take kind of a global view of the whole area. But I believe that the original thought was to kind of go down into the valley in case there was valley wells that we were going to use for drought supply.
And you can't serve water down there unless those lands are annexed.
Yeah.
And that's a public process through LAFCO.
Okay.
And they would have to also probably have an EIR associated with the infrastructure and the tanks and the conveyance facilities that would be needed to get water to any place remote.
Absolutely.
So thank you. That's all I had. I look forward to seeing.
Thank you,
Robin.
Robin.
Thank you.
Good question.
John Heinke proposed that we go down there and have a large well and bring it up Beale Road to the district for water use, and that's how the bottom part of this thing got expanded, just like Evan was saying. He was the director involved at the time. It's been largely forgotten since then, until I saw the map tonight. And probably when the board gets around to reviewing this, we may change the boundaries.
They change the boundary, and
Yeah.
Alaska may have a different, they have
Twist on it too, sure. Mhm.
You did pique my interest. I do have one more quick question for you. In the PG&E and the Miocene Canal and the water rights, did I understand you to say that if we divert the water to another use, that we would have to apply for additional rights?
No, I said that you may have to file a petition on the existing rights if you're changing something that the rights don't provide for.
So-
I don't know what they provide for yet. I don't know. I have not studied.
I think what she's saying, if we got the Miocene and wanted to use it up here, that's a change.
Well, and that's
Yeah.
currently what we're looking at, is that
Yeah,
not
it would
correct?
require not a new right, sir. It would require a petition, just like the petitions you're filing on yours.
That would take years to perfect again, huh?
Well, we're gonna look before we get ahead of ourselves. We're gonna look at what the
Yeah, because this,
what those
I mean, that's what
That's
you
our
said
due
is really
diligence
crucial,
that we
because
continue to do.
we're just assuming that if they were to give us that watershed, that we would be able to use it, and you just said we can't. Without certain,
Yeah, you'd have to.
well, exactly.
That'll be the due diligence.
It's not a guarantee.
It's a 20-year
Yeah.
20-year process.
Looking to buy them, right, I assume that you're going to be looking at what that water right allows for and where it
Right.
allows it to be used.
Exactly.
I'm hopeful it would be to change it.
I just
that's gonna
assumed
be
that it
part
was
of
already a
yeah.
given, that we could have it if they gave it to us. So I'm glad you pointed that out.
Mr. President, can we
Yes, sir.
have a break for the use of the
Well,
necessary?
why don't everybody done on this topic? I guess we are. Thank you very much. We will take a break. Thank you, Paula.
Very helpful.
Okay, we'll take a 5-minute break.